Every time I'm involved in arbitrations, I just don't understand why more companies aren't choosing to resolve their disputes via an arbitration process. I think there are really 5 key benefits to arbitration. The first is speed. When compared to the court's process, arbitration will be much faster to get to a final decision. Much faster. You can't underestimate the corrosive impact of delay in the court's process and the incredible opportunity cost for the participants, for companies involved in disputes associated with that delay. So I think the greatest benefit is you're going to get an answer to your dispute much faster. I think the second point is it's going to be a more efficient process. And in part, that's to do with the speed, because when the process is concentrated, the participants and the lawyers are more likely to be focused on what is essential. You just don't have the time and the luxury of being able to boil the ocean, so to speak, in a tight, constrained, disciplined arbitration process. The third point is control. The parties have the ability to streamline the hearing process, to modify the interlocutory processes, and therefore to have some control over the costs. And it's not just about making it cheaper, but it's about ensuring that the legal spend is more deliberate and more targeted and more efficient. The fourth is confidentiality. A court process, by its nature, must be open, and the information is therefore available to the public. Arbitrations are confidential, they're private. The benefit, therefore, is the details of the dispute are kept confidential. It can preserve business relationships. It can preserve the confidentiality of commercial information. And of course, it can provide protection against reputation risk. The fifth point is that it brings greater finality. And by that, what I mean is the appeal process for an arbitration is much, much harder. Now, of course, finality is double-edged. If you lose, it is very difficult to appeal. If you succeed, you can bring things to an end quickly. It doesn't mean there's no appeal option, but it means they're far narrower, far more constrained. In terms of certainty to businesses, finality must be a benefit. It must be a part of every company's consideration to think, when I'm in a dispute, what options are available to me to ensure I get a more cost-effective, timely, efficient outcome. And arbitration has to be one of those options. I think companies are less inclined to go with arbitration for a few reasons. Firstly, most arbitration occurs because the agreement on which they're having the dispute has in it a dispute resolution procedure that means it must go to arbitration. The parties in effect agree in advance that if they're going to have some dispute in the future, they will determine that dispute through an arbitration process. So that constitutes most arbitrations, the vast majority of arbitrations. So one reason people are not choosing arbitrations is they haven't chosen that as the dispute resolution mechanism for their agreement. And the second thing I think is just culturally. I don't think people are alert to the benefits of arbitration, the fact that you can voluntarily consent to arbitration, even if you don't have an arbitration clause in your agreement. And I think that leads to people just not thinking about it, or indeed having some reticence about what it might mean for them, and a lack of familiarity with the arbitration process. And the third is, it does require agreement. Often there'll be a party or both parties who believe they are better served in the courts and better served with the courts process, and whether that's a properly held view or not doesn't really matter if one side doesn't agree.